Finding a job and getting a green card on an F-1 visa. A guide for graduates. In the United States, May is graduation season for many university, graduate, and master's degree programs. First, I want to congratulate the class of 2026 in advance. Studying abroad, adapting to a new system, and overcoming academic, financial, and personal challenges is a major accomplishment. I wish all of you continued success in your next chapter. My name is Remzi Kulen. I'm an immigration attorney with more than 20 years of experience. In today's video, I will answer some of the most common questions F-1 students have after graduation. What happens after I graduate F-1 student visa? Can I stay in the US? Can I work? How can I maintain my status if I cannot find a job? Are there other options if I'm not selected for the H-1B visa? In this video, I will discuss the most common post-graduation options for F-1 students, including OPT and CPT, the difference between them, Day 1 CPT programs, the STEM OPT extension, the H-1B work visa, the green card and the PERM process, E1 and E2 treaty trader or treaty investor options, maintaining status by returning to school, and for some students, the possibility of pursuing a PhD and later considering the national interest waiver, also known as NIW. Before we begin, a brief reminder. This video is for general informational purposes only. Every student's school, graduation date, I-1 record, job offer, visa history, and long-term plans may be different. Before making any decisions, you should have your own situation evaluated by an immigration attorney. Also, before we get started, here is an important reminder that many non-citizens overlook. Until you become a U.S. citizen, you are generally required to report address changes to USCIS within 10 days of moving. You can usually do this through your USCIS online account by using the Change My Address tool. Alright, let's start now. Working while in school, on-campus employment and SSN. The basic rule for F-1 students is this: unauthorized off-campus employment while you are in school can create serious immigration status problems. F-1 students are generally allowed to work on campus while school is in session. During the academic term, this is usually limited to 20 hours per week. You cannot work for more than 20 hours. During school breaks, more hours may be possible depending on the circumstances. It is very important to speak with your school's designated school official, or also known as DSO, before beginning any on-campus employment. Another important issue is the Social Security number, or SSN. International students generally become eligible to apply for an SSN when they have authorized employment, such as an on-campus job, CPT, or OPT. Obtaining an SSN during your school years may make certain practical matters easier after graduation, such as renting an apartment, opening financial accounts, building credit history, or completing administrative processes. However, an SSN by itself is not work authorization. Your employment must always be consistent with your F-1 status and the specific employment authorization that applies to you. How about the CPT? What is it? How is it different from OPT? One of the most common concepts students encounter before graduation is CPT, or curricular practical training. CPT is employment authorization for an internship, practicum, cooperative education, or other practical training that is part of your academic program. And this is where the difference lies. It's a part of the academic program. The key point is that the work must be directly related to your field of study and must be an integral part of the established curriculum. For CPT, you do not file a Form 765 with USCIS. CPT authorization is handled by your school's DSO through CVIS and is reflected on your Form I-20. For that reason, on your I-20 form. For that reason, you should not begin CPT until you have an updated I-20 showing CPT authorization. Here is an important warning. CPT and OPT are not the same. CPT is generally used before graduation. OPT may be used before or after graduation, but for many students, it becomes relevant as post-completion work authorization after graduation. Also, if a student uses 12 months or more of full-time CPT at the same education level, that student may lose eligibility for post-completion OPT at that education level. For this reason, CPT planning should consider not only your immediate job or internship, but also your post-graduation OPT eligibility. In general, schools allow CPT after 9 months of education at the school. But there is a concept called Day 1 CPT, and it's pretty popular. So what is it? What is a Day 1 CPT? This topic has received significant attention in recent years. Day 1 CPT is not a separate visa category. It falls under the general CPT rules. In some programs, especially at the graduate level, if practical training is required from the beginning of the academic program, the school may be able to authorize CPT from the first term before even going to the school for a certain period of time. However, students must be very careful with this option. Day 1 CPT can be risky if it is used as a formality simply to continue working in the United States, and that's what USCIS is after. The academic program must be genuine, the student must participate in classes, the employment must be directly related to the field of study, and the school's CPT policy must comply with federal immigration rules. In recent times, we have seen students receive requests for evidence, or commonly known as RFEs, in connection with applications such as employment authorization or H-1B, especially where the student previously attended a Day 1 CPT school. The request for evidence is mainly about maintenance of status. Were you really going to school? Was the CPT program really directly related to your studies? These RFEs should not automatically discourage you, but it does mean that you should keep strong records. For example, keep evidence of in-person attendance to classes when required, including travel records such as flight, train, or hotel documentation if applicable. Also, keep records of attendance, certificate programs, transcripts, school IDs, Form I-20, and any other applicable documents. In short, Day 1 CPT may be a strategic option for some students, but if used incorrectly, it can create questions in the future. In the future H-1B, green card, or visa interview processes. Let's talk about the more commonly known OPT, post-graduation work authorization. After graduation, the most common option for F-1 students is OPT, for optional practical training. Post-completion OPT may allow you to work in the United States for up to 12 months after graduation. The employment must be directly related to your field of study. There are several important points to keep in mind for OPT. Your DSO must first enter an OPT recommendation in CVIS and issue you an updated I-20. After that, you must file Form I-765 with USCIS. Timing in filing the OPT is critical. If you do not file within the required window after the DSO recommendation, your application may be denied, and USCIS is not forgiving the applications which are not filed timely. So what is the time frame in which to file your OPT? You can file your OPT application 90 days before the end of your school term or 60 days after the end of your school term. Don't forget, you still need the DSO recommendation, but it has to be within this time period. Also, you do not need a job offer letter for an employer when filing the initial OPT application. You should also be careful. Do not begin working until OPT is approved and the start date on your EAD card has arrived. Your employment during the OPT must be related to your field of study. You must keep your address and employee information updated through your DSO or the SEVP portal. In addition, during post-completion OPT, more than 90 days of unemployment may put your status at risk. For that reason, instead of saying, I will apply for OPT first and figure out the job later, it is much better to begin your job search and planning early. I also want to clarify the 90-day unemployment period during the OPT. The OPT employment doesn't have to be a paid position. It could be an internship, it could be an unpaid position. As long as you have an employer you are volunteering for, you are working unpaid for, and it is an SEVP system, then you are fine. The 90-day unemployment only applies to periods where there is no employer in the file. Let's talk about the STEM OPT extension, which I think is the best hidden gem in the whole US immigration system. If your degree is in a field listed on the Department of Homeland Security's STEM designated degree program list, which falls under science, technology, engineering, and mathematics, you may be eligible to apply for a 24-month STEM OPT extension after your initial 12-month OPT period. This may allow you to have up to 36 months or 3 years of work authorization in total, which is great. The main STEM OPT requirements include, STEM OPT has additional requirements though. First of all, your employment must be enrolled E-Verify program. E-Verify is a federal program where your employer needs to check the employment eligibility of everybody hired in a federal system. So once they sign up for E-Verify, they can hire someone who has a work authorization based on STEM OPT extension, but they also need to run all the new employees through that system before offering them any position. This prevents the applicants who do not have work authorizations to work for these companies. The second requirement is job must be directly related to your STEM degree, which is also the case with the OPT. Also, the employer and student must complete Form I-983 training plan for STEM OPT students. Also, STEM OPT requires an additional application, and USCIS must receive the application before your current OPT expires. Your DSO at the school must enter the STEM OPT recommendation in CVIS and issue an updated Form I-20. There is an important benefit for students while the STEM OPT extension is pending. If the STEM OPT extension application is filed on time, and your current OPT EAD expires while the application is pending, you will be able to continue working for up to 180 days under certain conditions. This is a huge benefit because, as you know, USCIS announced that automatic EAD extensions are canceled, are not applicable anymore. This is one of the exceptions. When you file a STEM OPT extension before your OPT ends, you can continue to work for the employer until the application is adjudicated and up to 180 days. The unemployment limit is also a little bit different during the STEM OPT. As you know, the initial OPT period allows up to 90 days of unemployment. With the STEM OPT extension, the total unemployment limit will increase to 150 days. However, this does not mean students should treat unemployment casually. Your service records must remain accurate and up to date. Another big difference between STEM OPT and OPT unemployment period is that STEM OPT cannot be unpaid. So during STEM OPT, you cannot be unemployed or you cannot be working without getting paid. Let's talk about the H-1B professional worker visa. One of the most preferred visas is the H-1B work visa. H-1B is an employer-sponsored visa category for specialty occupation positions. I have a lot of videos about H-1B and you can watch those for eligibility requirements. But in general, the position must require at least a bachelor degree or its equivalent in a specific specialty field. The H-1B process is not something the student files alone. The employer files the H-1B registration on your behalf every year in March, and if selected, files the H-1B petition later. There have been important recent developments in the H-1B area. As of 2026, a wage level based weighted selection system has been introduced in the H-1B selection. This means that higher salaries, more likelihood of being selected in the registration. Therefore, registration for the H-1B is not as easy as it used to be before. If you are going to file for an H-1B, definitely retain an experienced immigration lawyer, the wage level and the occupation code well before the registration period, which is going to start in March. USCIS also introduced a new $100,000 fee for initial H-1B applications, which will be obtained through the consulates. But USCIS guidance has indicated that this payment does not apply to approved change of status cases from F-1 or OPT to H-1 inside the United States. So in general, it is safe to say that if you're filing for a change of status within the US to H-1B status, and if the case gets approved, you are not subject to the $100,000 fee. But you should not rely on general assumptions and talk to an experienced immigration lawyer. If you are selected under the cap subject H-1B process, the H-1B start date is usually October 1st, if not later. If your OPT expires before H-1B begins, you may qualify for a cap gap extension under certain conditions, allowing your F-1 status and in some cases work authorization to continue during the gap. So this is a huge advantage. Another important point is that an H-1B strategy through your own company may be possible in some cases. However, it is not as simple as saying I formed a company and I sponsored myself. The company must be able to act as a real employer. The position must qualify as a specialty occupation. Wage and labor condition application requirements must be met, and the company structure and supervision framework must be carefully prepared. Having said that, I am happy to report that we have gotten several H-1B applications approved in this area where the company owner has filed an H-1B for himself or herself, and the case was approved. So it is doable. In these company owner H-1B structures, it is important to note that the approval is limited to 18 months instead of the 36 months usually given by the H-1B visa status. But that 18 months can be extended. Let's talk about the green card and the PERM process. For some students, the long-term path may be an employer-sponsored green card process. One of the most common routes is the PERM process. This process generally involves three main stages. PERM labor certification handled by Department of Labor, I-140 immigrant petition handled by USCIS, and Form I-485 adjustment of status handled by USCIS, or consular processing if applying from outside the US handled by Department of State. A very important point for students is this: starting PERM does not automatically give you lawful status. Even if your employer begins the PERM process for you, you must continue maintaining F-1, OPT, STEM OPT, H-1, or another valid immigration status during the process if you want to stay in the United States. The PERM process can take a long time. Prevailing wage, recruitment, PERM filing, I-140, and visa bulletin timing must all be considered together. If your employer is open to green card sponsorship, it is important not to leave the process into the last minute. It may be possible to discuss a green card strategy during OPT or STEM OPT, but timing is critical. It is also important to try other options such as filing an H-1B during this process. How about E-1 treaty trader and E-2 treaty investor options? Although not suitable for everyone, E-1 and E-2 visas may be worth considering for some graduates. E-1 is the treaty trader visa. It may be available where there is substantial and ongoing trade between the US and the treaty country of which the applicant is a national. E-2 is the treaty investor visa. It may be available to nationals of qualifying treaty countries who make a substantial investment in a real, active, and operating US business. Eligibility for E-1 or E-2 depends heavily on nationality. Only nationals of countries that have the required treaty relationship with the US may qualify. For that reason, students should first confirm whether their country of nationality is eligible before building a strategy around E-1 or E-2. I have filed many successful F-1 to E-1 or E-2 applications in the past. For entrepreneurs, for young people who would like to conduct their own business, E-1 or E-2 is a great option. But it's also important to understand E-1 or E-2 is not a green card. It is generally a temporary non-immigrant status, just like any other non-immigrant statuses. The investment must be real, at risk, active, and not merely passive. For graduates considering entrepreneurship after school, the E-2 option should be analyzed carefully and professionally. Let's talk about returning to school to maintain your F-1 status. If your OPT is ending, you were not selected for the H-1B, or you do not wish to work immediately and you do not have any other options, starting a new academic program may be an option to maintain your F-1 status. This could include a master's program, a second graduate program, a PhD, a certificate program, or a community college program. However, there are two important points to keep in mind. First, the new program should have a genuine academic purpose. Enrolling in a program only as a formality to remain in the US will create risks for you. Second, it is important to note that not every new program will give you a new OPT or CPT benefit. As a general rule, students cannot repeatedly receive OPT at the same education level, and students cannot receive CPT at all education levels. For example, if you already used OPT after a second bachelor's degree, will not give you a new OPT period. A new OPT period is generally available when you move to a higher education level. For this reason, before assuming that you can return to school and later receive another OPT period, you should plan with your DSO and, when appropriate, with an immigration attorney. For F-1 students, after completing a program or OPT, there is generally a 60-day grace period. During this time, students may consider options such as departing the US, transferring to a new SEVP certified school, or beginning a strategy to change to another status. Finally, let's talk about the PhD and the NIW option. For some students, an academic career or PhD may also be a strategic path. Completing a PhD does not automatically result in a green card. However, some students, especially those building strong profiles in research, science, technology, health, engineering, artificial intelligence, data science, public interest, or other areas of national importance may later consider the EB-2 national interest waiver or NIW. The importance of NIW is that, unlike the traditional PERM process, qualifying applicants may be able to file an I-140 immigrant petition on their own behalf without employer sponsorship and without labor certification. This is a self-sponsorship mechanism. However, NIW is not suitable for everyone. Simply having a master's degree or beginning a PhD or doing what you do great is not enough. Just being successful is not sufficient for NIW applications. The applicant's field of expertise, the national importance of the proposed work in the U.S., publications, citations, projects, expertise, recommendation letters, industry impact of what you have done so far, and future contribution should all be evaluated together. For that reason, students considering a PhD should not think only about the degree. They should plan their CV, research area, and long-term immigration strategy together. In summary, there is no single path after F-1 graduation. For some students, OPT may be enough. Some may obtain up to 3 years of work authorization through STEM OPT. Some may transition to H-1B. Some may begin an employer-sponsored green card process. Some may consider E-1 or E-2 treaty trader or treaty investor options. H-1B is a very common option, but others may continue with a new academic program or PhD as part of a long-term strategy. The most important point is to move forward without losing status, without waiting until the last minute, and with proper documentation at every step. This has become more important during this administration. The post-graduation period is exciting, but it is also very sensitive from an immigration perspective. Unauthorized employment, late filings, improper CPT use, or failure to update CVS records can create serious problems later. Before graduating, make sure you know the answers to these questions. What is my OPT filing timeline? Is my program eligible for STEM OPT? Is my employer enrolled in E-Verify? Is my employer prepared for H-1B? Is a green card process possible? And what is the best strategy for me in the short term and in the long term? Congratulations again to the class of 2026. I hope this video helps you better understand your options after graduation. If you have any questions, you can leave them in the comments section. If you want to evaluate your own situation, it is important to seek professional guidance. See you in the next video.